Hello, everyone. Good afternoon. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the most positively reviewed employment law firm in the country. Here for another edition, yes, yet again, another edition of our employment law Q&A sessions. It's an opportunity that we give to the public at large to ask your employment questions, to try and resolve your workplace concerns, really anything that you are worried about when it comes to your work, when it comes to your employment. If you're worried about a termination or a temporary layoff, or if you have an issue about pensions or an issue about your pay, this is your chance. If you're watching this, this is your opportunity to chat with us. Type in your question. I will make sure to tackle it. I will give you the information that you need to resolve your workplace issue. Again, whatever that issue is, as long as it's related to your employment, we can tackle it here on this very show. It's also an opportunity to talk about some disability insurance law questions. So related to employment is disability insurance law. If you're on a medical leave, if you're having issues with your disability insurance, go ahead and ask away. We always start with a couple of pieces of contact information at the start of the show. You need to know where to reach us if you want to get a hold of us and you're not on this live stream right now. First place to visit, employmentlawyer.ca is our website. Employmentlawyer.ca, you see it on the screen right there. We've got a ton of resources online, blog articles, video clips, lots of resources. I mean, you name it. If it is under the rubric of employment law, you will find it on our website. It should be your first point of contact. There's also our contact information on our website. If you want to reach us and get a hold of us specifically, you'll find all of our email addresses and contact information, including our main email address, help@employmentlawyer.ca. Again, you see it on the screen right there, help@employmentlawyer.ca. Do not be shy, folks. If you have a question about your employment, email us at that email address, help@employmentlawyer.ca. Give us a brief description of your situation. I promise someone will get back to you and answer your question or put you in touch with an employment lawyer. Those are the two main ways in which to get a hold of us, our website and our email address. I'll mention it over the course of the show as well. But for now, let's get those questions coming through. Let me help you answer those employment law questions. And by the way, everyone, by asking a question here, you're not only helping yourself, I mean, you're undoubtedly helping yourself by getting your question answered by an employment lawyer, but you're also going to be helping hundreds and hundreds of other individuals out there who are watching this at the very moment or watching this after it's been recorded and are wondering the same exact thing, have the same exact employment law concerns, are dealing with the same exact situation. We see it all the time. So not only are you helping yourself by asking your question, you're helping thousands of others out there that are dealing with the exact same situation. I'll give you a very recent example of that happened, I guess, a couple of weeks ago now on the radio show. We host a radio show as well in Ontario and in British Columbia and Alberta as well, for that matter. But a gentleman called in and was asking about temporary layoffs. And so his employer had very recently temporarily laid him off. They said, listen, we don't have work for you at the moment. We're going to send you home and we'll call you back to work when we're ready. So this gentleman called into the show and he's saying, well, I'm not sure if what my employer is doing is legal here. I've never been laid off before. I know with COVID times are tough. I'm wondering if an employer is actually allowed to do this. And what we've told him, as we tell all of the other individuals who have been temporarily laid off, is that if you've never been laid off before, and if temporary layoffs are not an established term of your employment agreement, if there's no contract that says an employer is allowed to lay you off, then a temporary layoff can be treated as a constructive dismissal. It's basically a termination, in which case you are owed severance. So what I told this gentleman live on the air was, well, actually, if you'd like to, and it might be preferable to, you can treat the temporary layoff as a termination, get your severance entitlements, and get moving on with your life. That is actually a better option as opposed to accepting the temporary layoff And the problem with accepting a temporary layoff, even if it might be for a brief period of time, let's say it's a few weeks or maybe even a month, the problem with that is once you accept one temporary layoff as part of your employment, you then allow, or you are allowing your employer to consider that a permanent term of employment, meaning they could do it time and time again. If you don't reject the first temporary layoff, you can't reject the second. It becomes a term of your employment. And having said that to this individual on air, I actually received an email from another individual who was listening into the show at that very time, who was in exactly the same kind of situation. So again, if you're dealing with an employment issue, you're not alone here. We are here to help you as employment lawyers. And there are also other people in the same circumstances that can learn from the advice and the information we share with you. So again, guys, do not be shy. I see a couple of questions coming through already. I'm going to get to them in a second, but do not be shy. Even if you think your question is very simple, even if you think your question is even a little silly, listen, when it comes to employment law, there are no bad questions. There are no silly questions. They are all important. They are all educational. And you are doing yourself a service, and you're also doing others a service. So with that out of the way, guys, and I also wanted to touch on the issue of mandatory vaccination policies in a sec, but questions always are given priority, so let's get to them. The dreamer is first in line, and he asks, or she asks, does an employer have to accommodate students going back to school or going back to work full-time when finished school? So, Dreamer, if we're talking about the phrase accommodation, it brings to mind effectively a human rights accommodation, meaning an accommodation based on somebody's disability or perhaps their religion or perhaps their gender, etc., on these protected grounds under human rights legislation. That is when the language of accommodation is used. For example, someone with a medical disability who needs assistance in doing his or her job requires accommodation on the part of their employer. An employer cannot simply terminate that employee because they have a medical disability and can't perfectly do their job. That employee needs to be accommodated, whatever that accommodation might look like. Now, if we were talking about students and going back to school, Dreamer, that is not a protected ground of accommodation. And so I think you're using the wrong language here. It's not necessarily that an employer has to accommodate you. No, there's no obligation there to accommodate a student per se. If there is an agreement between an employer and an employee that they will allow you to go back to school and you'll be able to, move to part-time hours or maybe even put your employment on pause while you're at school, well, then that agreement or that understanding needs to be respected, right, and needs to be followed. But there's no inherent right that you as a student have to keep your job if you're not able to work anymore because you're going back to school. Same thing, and I think the second part of your question is, well, going back to work full-time when you finish school, again, there's no inherent right that a student has that ability. That said, if there was an agreement between you and your employer to that effect, and they are now reneging on that agreement, well, that's the problem for an employer. You would be able to require the employer to hold up its end of the bargain if that's what it looks like, or otherwise you might be owed some damages as a result, effectively severance. So it really depends on whether there was already an agreement in place or not. Dreamer, again, a student doesn't have an inherent protected ground to be accommodated like someone who would, for example, be disabled and unable to work or have to take time off for a medical disability. Those issues can be distinguished. Feel free to follow up if you have any other questions or concerns. By all means, provide some additional context. Again, you can email us at help@employmentlawyer.ca. We can have a chat off air, off live stream, so to speak, and get into the details of your situation. A lot of times, before you make a decision, whether it's resigning from your employment, whether it's committing to some sort of position with your employer, you want to get legal advice. You want to speak with an employment lawyer in your province before you make any kind of decision, certainly any kind of definitive decision with respect to your employment. Again, whether that's accepting new terms of employment or allowing your employer to do something that you're not particularly comfortable with. Before you say yes or no, right, before you commit one way or the other, you've got to make sure that you get some advice. And that means speaking to one of our employment lawyers here. Once again, for those of you just tuning in, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin, LLP. I'm a partner with the firm. I don't know much about other areas of law. Don't ask me any family law questions. But if you have a question about employment law, if you have a question about what's going on at your workplace, whether you think it's right or wrong, whether you think you're being treated fairly or not, go ahead and ask your question. I promise I will get to all of your questions before the end of the show. We've got about 20 minutes left right now. Still plenty of time to ask those questions. Please ask away. Next in line, Kev Love asks, if you're put on unpaid leave for not getting vaccinated, hot topic, I wanted to talk about this today, and told by a lawyer you're not entitled to severance, can I get back pay if I'm called back to work for the time I was on unpaid leave? Interesting question, Kev Love. I'd be curious to know why you were told by a lawyer that you're not entitled to severance. There are certain circumstances in which an employee who's put on unpaid leave isn't entitled to severance. Just to name a few, I mean, in Ontario at least, there are some industries, very few at this point, but there are some industries in which it is actually required by the government to be vaccinated. If you work in a long-term care home, for example, you need to be vaccinated in order to do your job. That's not up to your employer, to be clear. That's up to the provincial government in Ontario. And that means if you're fired for not being vaccinated, working in a long-term care facility, then you would not be owed severance. Or to your point, Kev Love, if you are put on unpaid leave as a result of not being vaccinated, and let's say you're in one of those industries where you need to be vaccinated according to the government, then you wouldn't be owed back pay, Kev, as a result of being put on unpaid leave and then called back to work. There are other examples as well, and I would say few of them, but there are other examples as well where an employee might not be owed severance as a result of a vaccination policy. That said, I want to be clear, for the vast majority of non-unionized employees out there, these vaccination policies that put an employee on unpaid leave or allow employers to terminate employees without severance, those are illegal. An employer is going to have to pay an employee severance. And to your point, Kevlav, that severance might also include back pay if the vaccination policy is unenforceable, if it is effectively illegal. It doesn't mean we can get you your jobs back necessarily. It would mean that you are owed severance. So Kevlav, feel free to let me know why a lawyer told you that you're not entitled to severance. It may also mean that you're not entitled to that back pay from the date of your unpaid leave to the date, let's say, you're called back to work. But again, if that's the case, you're probably in a very particular situation or very particular industry that's out of the norm. In most cases, employees are going to be owed back pay from the date of their unpaid leave if they're put on unpaid leave. I mean, being put on an unpaid leave is effectively a termination, right? Being sent home without pay, even though you don't have a termination letter in your hand that says your employment is terminated, the very act of sending an employee home and not paying them is a termination. It's basically a breach of contract in the employment law world, and that entitles an employee to severance. You can consider that back pay if you want, Kev. But listen, we'll have to look at the specifics of your situation. If you've spoken to one of our lawyers already and you've been told that you're not owed severance, again, you might be in one of those few employees that actually applies. And if you'd like, again, leave a comment and I'll chime in myself. Otherwise, you would potentially be owed that unpaid leave or that back pay, as well as severance, depending on your age, position, and years of service. All right. DS Joe 87 asks, are you seeing more companies adding the third booster shot to their vaccine policy, or are companies starting to scale back on vaccine policies? Great question. It's an interesting one for the most part. And listen, in case it's not obvious, as employment lawyers, and particularly, again, in the province of Ontario, and also I've heard from my colleagues in BC and my colleagues in Alberta, I can tell you, for the most part, employers seem to be doubling down on their vaccination policies and letting employees go, either with severance or without severance, as a result of employees not abiding by these vaccination policies. I haven't seen many require booster shots as kind of a new term of the vaccination policy or an update of the vaccination policy. I think, again, we've spoken to hundreds and hundreds, if not thousands, of people across our firm with respect to these vaccination policies. I think I might have seen one or two employers introduce booster shots as part of these new policies. I have seen a few employers as well scale back their vaccination policies and actually either do away with them or alternatively revise them to either recognize natural immunity. So someone who has had COVID previously, that would be recognized as well as a form of immunity other than vaccination. Or, for example, amend vaccination policies to allow employees to either work from home or to take rapid tests, for example, instead of requiring vaccination. I mean, those to me seem like very reasonable options here, rather than having to let an employee go. Having employees do rapid tests, etc., would have been, over the course of the past several months, a much more reasonable way to deal with COVID-19 and with making sure that an employer is meeting its health and safety obligations in the workplace. That said, I expect that in Ontario, now that vaccination policies or vaccination requirements kind of for restaurants and for kind of public gatherings are no longer required, I do expect over the next couple of months that employers will start to back down on this issue. It should also be mentioned for those employees who were let go as a result of a vaccination policy and not offered severance. And there are many employees out there who were not offered severance because they were let go as a result of not being vaccinated, not following a vaccination policy. Listen, again, given the easing of these restrictions with respect to vaccination, I don't think there could be any doubt at this point that those employees are owed severance and owed their full severance entitlements, regardless of the circumstances of their termination. They're going to be owed their full severance entitlements based on their age, their years of service with the company, and their position with the company. And an employee's severance entitlements for those longer service employees, and especially those employees that are older, they can amount to as much as 24 months of pay. We've seen those kinds of cases. Long service employees, older employees that have been with an employer forever, be let go with absolutely no severance simply because they didn't feel comfortable being vaccinated. And again, I think there's no question now that these employees are going to be owed severance. Unfortunately, these employees can't get their jobs back. If their employment has been terminated, there's no way we can mend that relationship and get that employee their job back, but they are undoubtedly going to be owed severance. I don't think there can be really any dispute about that now. All right, Videoland asks, regarding the vaccination policy, can a win in arbitration help keep our jobs or just get us severance? Videoland, your reference to arbitration refers to a unionized work environment. And so in a unionized work setting where it is the union challenging a decision of the employer, either challenging the vaccination policy or challenging an employee who's been terminated, challenging the termination, in an arbitration, in a unionized setting, yes, a union can get an employee their job back. It's actually one of the, I would say, few benefits to being a unionized employee. If you're wrongfully let go as a unionized employee and your union decides that they agree with you that you were wrongfully let go, they will be able to challenge or to grieve, it's called a grievance, they will be able to challenge the employer's decision. And if the union is successful, you will get your job back as a unionized employee. In the non-unionized setting, Videoland, there is absolutely no way a court or a mediator or an arbitrator or us as employment lawyers, there is no way that we can guarantee, or there's no legal mechanism by which an employee can get their job back if they've been let go in a non-unionized workplace. The best case scenario for a non-unionized employee who's been let go, and let's say that's specifically related to a vaccination policy, your best case scenario is that you are going to be owed severance. And you will likely be owed severance as a non-unionized employee who's been let go as a result of a vaccination policy. So that is a positive thing. On the one hand, you are definitely owed severance. Of course, in the non-unionized environment, there's no way to get your job back in a situation like that, unless by chance your employer offers you your job back. I can tell you from the people that I've spoken to who have been put on unpaid leave or let go because of a vaccination policy, the majority of these people don't want to go back to their jobs anyway. They have no interest in going back to an employer who let them go or who put them on leave because of a vaccination policy. In large part, these employees want to get their severance entitlements and move on to a new employer who hopefully will be, treating them better. Really interesting question though, Videoland, and I appreciate it. We often discuss here on this show the difference between unionized employees and non-unionized employees. For non-unionized employees, your severance entitlements are much, much stronger. And you actually have a lot of different tools that you can use as a non-unionized employee to protect yourself against an employer. You have a lot of options. You have, pretty strong rights as a non-unionized employee in Ontario specifically. For unionized employees, there are some advantages for sure. You might have, better job security, as I was previously mentioning. Your pay might be a little better. Your benefits might be a little bit more secure or a little better. But when it comes to things like severance, when it comes to things like fighting changes to your job, either pay reductions or temporary layoffs or kind of negative changes to your job, actually a unionized employee is going to be quite limited in their severance entitlements and their ability to kind of fight their employer. Keep in mind, the unionized employee can only be represented by their union. They cannot go to an outside employment lawyer and fight for themselves and fight for their own rights. It's the union that decides what the union is going to fight for or not fight for. And a lot of times that relationship between a union and an individual employee isn't all that it's really chalked up to be. Lots of employees are oftentimes disappointed with their union because they won't fight for them. And that's obviously a difficult situation. All right, moving on to the next question. Guys, keep it coming. We've got about 8 minutes left here on the show. I am more than happy to answer more questions, even if they're related to medical leaves of absence or disability insurance. Again, something else that often comes up in the employment context. I'm more than happy to, more than able to tackle. By all means, ask away. Next question, James asks, my employer refused my religious belief and my rapid testing, and I was terminated. They told me I had to take the vaccine, and they're not accepting the religious belief or the rapid testing. James, I have heard from lots of people in exactly that situation. It's unfortunate. It's unfortunate because the truth is, I don't think I've seen one religious belief kind of defense to vaccination policies actually be successful. And I don't feel that's particularly right. I think those views oftentimes should be respected, or at the very least kind of investigated a little bit in a little bit more detail. I've seen many employers just simply bat them away without giving them a second thought. And again, that's just not right. With respect to rapid testing, listen, James, I agree as well. I think rapid testing for the past 6 months, if not more, for the past year, has been a perfectly useful tool in order to keep employees safe, and allow employers to meet their health and safety obligations if employees are actually attending the workplace, right? Rather than requiring employees to confirm their vaccination status or not, even though, listen, rapid testing is not perfect. It's not the end all and be all of keeping you safe from COVID, but it is effective. And it's an assurance that you can at least allow employees with kind of very minimally invasive technology to undergo rapid testing and confirm whether they have COVID or not, and kind of, keep a workplace as safe as possible, really, without perfection being the standard, which it isn't. And so I agree with you, James. And if you've been let go, despite suggesting rapid testing, despite suggesting, that you had religious beliefs that you wanted respected, listen, if you're a non-unionized employee, to get you your job back, James, is not likely. If dare I say, it's impossible. However, there's no question, James, you're going to be owed severance in your circumstances, unless you were working in a long-term care facility. For example, you are going to be owed severance. Your severance is not going to be 1 or 2 weeks per year of service. Actually, we've got a nifty tool that you can use if you want to calculate your severance. Go to pocketemploymentlawyer.ca. You fill in a little bit of information. It's completely confidential, and you will know what your severance entitlements are based on your age, position, and years of service. Very nifty tool. It was just on the screen there. Pocketemploymentlawyer.ca is where you can find out what your severance entitlements are. There's also a couple of other things Pocket Employment Lawyer can do with respect to terminations and changes to your employment. You might want to visit that website just for fun. Even if you haven't been let go, even if you're perfectly safe in your job, go to pocketemploymentlawyer.ca. You can just play around with it, fill in a couple of kind of point form questions, and out will come a response, and you'll get a sense of what rights and protections you as an employee will have in the workplace. Last couple of minutes here, guys. 4 minutes left, and just in the nick of time, another question here from I'm not going to pronounce that name, but here comes the question. I got another job immediately after I was placed on unpaid leave. Interesting situation. My old employer says I'm not entitled to severance as they deemed me to have abandoned my work. Are they correct? That's quite interesting. I don't think an employer is correct in that situation, because you can consider, and again, let's keep in mind here, this is assuming you are a non-unionized employee. So if you are a unionized employee here, the analysis is going to be different, and you're going to have to speak to your union about this. But as a non-unionized employee, if you were placed on unpaid leave, likely amounted to a termination of your employment. That means before you found that next job, your employment was actually terminated, in which case you are going to be owed severance. Now, the fact that you found a new job so quickly might affect the calculation of your severance entitlements, but you are still going to be owed a certain amount of severance. There's no question about that. Again, assuming you're non-unionized and assuming that there's no government mandate in place that requires you to be vaccinated as part of your employment. Don't just assume that what your employer is saying, that they've abandoned your employment, which is a fancy way of them trying to not pay you severance. Don't assume that that's correct. You are going to be owed a certain amount of severance. Give us a call. Send us an email. Again, the website address is employmentlawyer.ca. You can find our contact information there, or you can email us at help@employmentlawyer.ca. Give us a brief description about your situation. You can even attach a couple of documents if you like. It's completely confidential. And someone, I promise, will get back to you. Just under the wire here, Marvin, better late than never. Marvin asks, you were hurt on the job. You smashed your face. That sounds painful, Marvin. WSBC, I assume you're out of British Columbia here, paid for T3s and muscle relaxers and said I could have driven. I'm a class 1 driver. I don't see a question there, Marvin, but what I will tell you is email your question at help@employmentlawyer.ca, and someone out of our Vancouver office will get back to you if you're in BC. We will leave it there, folks. Thank you so much. You can catch the next edition of Employment Law Q&A live tomorrow at 1:30 p.m. Eastern Standard Time with my colleague, the knowledgeable Samara Belitsky, going to be on air to take all of your questions and tackle some more employment law issues. Until then, I hope everyone has an excellent rest of the week and an excellent weekend. Thank you all so much for tuning in. Until next time, we will see you.